Hi, good afternoon. This is Ruby Powers with Powers Law Group, immigration law firm, and it is Friday afternoon, March 30th, 2018. Good Friday. We're starting fashionably on time. I mean, a little bit late, actually. But anyway, we're here. And hopefully you might have a break today. Maybe you're not. Maybe you don't have school. But, we're here to give you our weekly update. So we're going to give you highlights of the news and what we're doing, and then I have some questions about E2 visas today. So this week in the news, just yesterday, so this is sort of a good thing, a judge ruled yesterday that the Department of Homeland Security has routinely failed to notify applicants that they have a 1-year filing deadline for asylum after they're released from detention. So this was just announced last night. Everybody was super excited because it was a court in Seattle. So, was that Pacific time. So we're still taking it in, but the news is out, and it basically says they've opened the door for thousands of immigrants to apply for asylum because DHS has routinely failed to notify them of the deadline. A lot of people have been told to appear in court, but they typically aren't personally told that they have a 1-year filing deadline. The lawsuit argued. So the judge ordered the department to begin providing notice about the 1-year deadline within 90 days anytime an immigrant seeking asylum is released from custody pending deportation proceedings. He also said the department must give those who miss the deadline another year to file their application. So that is great news. This could apply to you, a friend of a friend, somebody you might know. Somebody was detained, released, and missed their 1-year filing deadline for asylum. They might still be eligible under this provision that was just announced, this case law that was announced last night. Defendants have left class members without an adequate mechanism to timely file their asylum applications, thereby denying them the opportunity to exercise their statutory right. The federal law does not require officials directly notify asylum seekers of the deadline upon their release, the government argued. But, many people have been released and then they don't have a hearing for a while. And by the time they show up, they might have missed their 1-year filing deadline, especially if they never went to an attorney or knew what the law. Many people miss that 1-year filing deadline because they don't know the asylum law in the United States. There was a recent article from The Hill, based out of D.C., basically just summarized, we know this, a year of fear under immigration policy under Trump. It basically talked about the travel bans, ending DACA, ending TPS, abandonment of prosecutorial discretion. So, changes with H-1B. We've also seen changes with the Department of State, as well as Buy American, Hire American focus with employment-based immigration. So, so that summarizes everything that we've been dealing with directly as an immigration law firm with trying to give the best advice to our clients. And that was also further elaborated in a recent Rolling Stone article that is quite lengthy. Haven't had the chance to read it all. It's about 20 pages, I believe. But it goes into a lot of detail along the same lines that The Hill summarized as well. And the other thing that we have is that, there's a Washington Post article, Trump proposal would penalize immigrants who use tax credits and other benefits. So President Trump is proposing denying any form of welfare to immigrants on the road to permanent residency. As to what that's welfare has bad connotations, but is a loaded word, but in some cases using some type of public benefit. So this is a proposal that is waiting to be approved, but is quite lengthy. The draft proposal has been obtained by Washington Post recently, and they gave us a summary in an article a couple days ago. According to this article, the proposed draft, caseworkers would be required to consider a much broader range of factors when determining if immigrants are receiving public benefits. The change could apply to those seeking visas or permanent residency. We've already seen changes with the Foreign Affairs Manual on interpretation of the I-64 along these lines. So this isn't a shock, but we're really also not sure exactly how it's going to be adjudicated, and if it's going to be consistent from case to case, which very likely won't be if there's any amount of discretion involved. And also, generally, when a new policy or memo is rolled out, it takes a while to have uniform training and understanding of what that means. While these changes are meant to prevent a high influx of immigrants from, the article, it's mentioned, stealing benefits, USCIS found that out of 41.5 million immigrants living in the United States, 3.7 received cash benefits in 2013, and 22.7 accepted non-cash benefits, including Medicaid, housing subsidies, or home heating assistance. So very little on the cash benefits, and 22.7 on non-cash. But in many cases, they are already prohibited from having some of these benefits because of the affidavit of support. And additionally, they might be receiving some of these benefits for their U.S.-born children, which is allowed. So we'll see how that plays out, but we need to keep an eye on that one. And another one that just came out yesterday is well, I'm getting ahead of myself for so much every week. Well, yesterday, I mean, ICE paves the way to detain more pregnant immigrants. So the Trump administration will no longer seek to automatically release pregnant immigrants from detention, a move in line with the overall efforts by the administration to hold far more immigrants in custody. The decision comes as immigration advocates have assailed the administration's efforts to hold more immigrants in detention. So basically, if a woman is detained and she's pregnant, she's been historically allowed out of detention so that she could find help and give birth not detained. But now they're saying the policy will require a case-by-case evaluation, and that will keep in custody only those whose detention is necessary. So because the focus is removal. And it's to make clear to the policy is to make clear that the administration's policy is that no immigrants are exempt from enforcement, not even pregnant women. Oh boy. So the other thing that's really hot in the news right now is that you know how you have a census in the United States every 10 years, they count how many people we have, and they ask a lot of things of ethnicity and location and age, and they just, they keep that data and they use that for lots of different things. Well, anyway, the next one's going to be in 2020, which is coming up. It takes a while to get prepared, and they're going to add the question about citizenship. And so this is a question about citizenship status will be included on the 2020 census to help enforce Voting Rights Act, federal officials said. But California sued to block the move, arguing it would discourage immigrants from participating. The census, which is mandated under the U.S. Constitution and takes place every 10 years, counts every resident in the United States. It's determined allocation of states. Oh, yeah, that's right. That's the other reason why we need it. It's because it helps allocate the states the number of seats we need in the House of Reps, and also distribute money for funding. So the thing is that I remember in 2010, if people who are coming around asking census takers if the person knows they're going to have to ask about citizenship, and the person is supposed to tell the answer to that, many people are just going to avoid being taken in the census. And then immigrants are going to be afraid that if they tell the answer, that can come back to haunt them. And then maybe that will be used. Exactly. Test surveys show in late 2017 that some immigrants were afraid to provide information to U.S. Census workers because of fears of being deported. Census researchers have said immigrants that they've interviewed spontaneously raised questions about travel ban and dissolution of DACA. The possibility that the census could give my information to internal security and immigration could come and arrest me for not having my documents terrifies me. And that is going to cause a big problem if they have that question on the census. And the article that I was mentioning about the welfare public charge grounds, there is a policy that has been proposed, and this is the one that we've we've been seeing it creep into lots of different interpretations for the I-64 and public charge from the Foreign Affairs Manual, and now we're seeing it with the Department of Homeland Security. So those are our week in news, and I just want to also say that we went to the ICE liaison meeting with other immigration attorneys. I went yesterday, and one thing that we know now is that under the Obama administration, there was more of a focus on people with prior removal orders who had from a certain year on, as well as people who had certain level of crimes, more like serious crimes were a priority. But from what I understand, what we've seen and what I heard in the meeting, it is more, a prior order is a prior order, and that is equally important than anybody else who has a prior order in terms of people who they are making a focus of finding and trying to process. So we have to keep that in mind through all our planning. So I'll go ahead and go with some questions we might have.
So this first question comes from the audience.
Okay.
And they have a question there from Venezuela. They're a Venezuelan citizen that just arrived in Chile. And they want to know if an American resident could help them get to the U.S. or if they should follow through with a visa.
Okay. So a Venezuelan is in Chile, and well, you can try to apply for a visa, but that can be difficult from Venezuela right now for a tourist visa. But I think that question is better suited with a consultation because it's very specific, and we might have some information we need to collect to be able to help better answer that. But you can give us a call at 713-589-2085, or you can email, if that's easier, contact at rubypowerslaw.com. So we have that right over here for you to reach out, and you can find it on our website and our Facebook page. But thanks for asking questions, and we'll try to help you as much as we can in this venue. Otherwise, a consult is a great way to get a lot of information.
This next question is about E2 visas. Can my spouse work in the U.S. once my E2 visa is approved?
So if the E2 is approved and the primary is working in the business, their spouse can work if they have the valid work authorization approved. That's what's so great about the E2 visa. It's a great visa.
So now some of our viewers are asking specifics about E2 visa. Could you please explain what the E2 visa is?
So basically, you have to be a national of a country that has a treaty with the United States. For example, Mexico or Spain or Pakistan have treaties with the United States, so that if a national from those countries were to invest and create a substantial business of some sort, we have certain requirements, then they would be able to be given a short-term visa that will allow them to remain in the United States. It's a non-immigrant visa, and they have to have the intention to return home. But there have been stories of people having an E2 visa for 10 years or so, and maybe changing into an EB-5, or their children might become Americans and petition for them. I mean, they might become 21 and American and petition for them. So it's a great visa to open up business in the United States. And then you don't have to open a business. You can also be an employee of a company that if you're of that nationality of the company.
Can my children attend school once my E2 visa is approved?
Yeah, they can. They can attend school. So spouse can work and kids can go to school.
Now, what happens after an E2 visa is submitted to the embassy?
So basically, it's good to remember that you can apply for the E2 at the U.S. Embassy or consulate in your home country. Sometimes you can go to a third country that will accept it. It's not your nationality. Or you can apply for it in the United States. So generally, whichever one of you do consular processing or through USCIS, it's a little different. But at the consulate embassy, you submit it in advance. They give you an appointment, and then you can go there, and they'll interview more about your business.
Can I renew my E2 visa while in the U.S.?
You can. So, like, if you were to get your E2 in the embassy in your home country, and then you came to the United States, and you're just really busy and you just can't travel because you're growing the business, you have kids or whatever, you can file for an extension here in the United States. It can cause a little can get a little complicated where you have to go back to get a stamp to come back in when you're traveling, but you can apply for it here in the United States.
Is there a minimum investment for the application concerning an E2 visa?
There isn't. There isn't one, and depending on which attorney you talk to, they've had different experiences. Many cases, people, I think the smallest investment we've ever had been successful with was about a $40,000 or something like that, $40,000. But there's not a set number, so it really depends on your business. So if it's a small dog grooming store or something like that, you get the office space, you get a website, you get maybe an employee or so, and some of the things that go inside. It might not take a lot of money initially, but if you have a grocery store or a hotel, that's a lot more of an investment. So it depends on what type of business you have.
Do you have to employ a certain number of employees, and do those employees have to be U.S. citizens?
Yeah, no, you don't. So basically, you don't have to have a certain number of employees, and they don't have to necessarily be U.S. employees, U.S. citizens. This isn't the EB-5, which does require U.S. workers and 10 employees over the course of 2 years. This is different, but you can have a variety of people that isn't required in that sense. So here at Powers Law Group, we have 3 attorneys, and one of them focuses majority of their time on employment and investment visas, and that's Michelle Strickland. And so you can give us a call at 713-589-2085, and we've helped people with E2s from all around the country, all around the world, and all different types of business. So, I, as a business owner, my firm's 9 years old. I've done the Goldman Sachs 10,000 Business Program. We're strong supporters of small business, and we try to help people with those E2 investments. So, please give us a call if you're interested in that. And just in closing, I will be traveling to Harlingen Sunday, Monday for a court case. So I'll be there. Some of our clients live down in the valley, but it is Easter weekend for those who celebrate. And we've been traveling a lot more recently for asylum interviews in court. And so whenever we have clients in different parts of the country that we're traveling to, it's always great to be able to see them if we can. And the other thing is that I will be in DC April 11th to 13th for National Day of Action to help advocate for immigration reform. So I'm going, not getting paid, going there because I care about immigrants and I care about immigration reform and policy. And this is something I've been doing for many years and helped organize. I'm the chapter advocacy liaison and oversee a group of captains throughout the Texas, New Mexico, and Oklahoma. And while I'm there, I'm planning on going to New Jersey for a few days as well to meet with people. So give us a call if you're interested to know more about my travel plans, but to schedule a meeting or consult. But again, thank you so much. I hope you have a great weekend. And this is Ruby Powers signing off with Powers Law Group. And hope you have a great weekend. Thanks for listening.